Third case on this morning's docket, case number 113563, Douglas R. Peters v. Deseret Cattle Feeders, LLC.
May it please the court, Alan Roop and Jeremy Schrag for the petitioner, Deseret Cattle Feeders. This is a contract case involving employment in which Mr. Peters claims he had an implied contract as opposed to an express contract with Deseret Feeders that protected his job from a layoff. This case looks at what it takes to turn an at-will arrangement into an implied contract that Mr. Peters claims he had that gives him what he claims is job security for life. This case started in the summer of 2010. Mr. Peters was a shop mechanic at a feedlot in southwest Kansas. And the owners of the feedlot at that time, Hitch Feeders, began negotiations with Deseret in order to sell the feedlot to Deseret. They had a series of meetings with employees in which sometimes Deseret was there, sometimes the Hitch folks were there, and Deseret encouraged the feedlot employees to stay on when the ownership changed and was transferred to Deseret. Peters and some others were told that if they did their job and performed their job, they would have continued employment. And that continued employment would continue after the sale of the property. They were going to get rid of people by attrition, not by firing or not by layoffs, was the optimistic comments that were made during the course of the department meetings.
And those comments were made, weren't they? You characterized them as optimistic comments, but they were comments that were made to the employees of Hitch.
They were comments that were made to the employees of Hitch. There's no doubt that they said if you do your job, you'll have continued employment. And there's no question that they said if there's attrition, there's attrition, and we'll try not to, I think they said we don't plan any layoffs, was the comment that Mr. Peters recalled being said. So about 9 months after the sale in November of 2010, the shop mechanic position was eliminated. Mr. Peters was laid off. The shop mechanic position was one in which equipment was repaired and they had changed out the equipment and there was no longer a need for his position and he was laid off. He then filed a lawsuit in Haskell County District Court arguing that and alleging he was wrongfully terminated. The Haskell County District Court judge indicated that it was an employment at will situation, that those optimistic or statements of employment conditions that were indefinite and infinite could not form the basis of an implied contract, and the trial judge said, no question, this is an employment at will situation. Mr. Peters could be terminated any time for any reason.
Counsel, how do you get around paragraph 3 of those affidavits that are floating around, where these witnesses said just that any reduction in workforce would be limited to reductions by attrition?
I see that in the same. We discussed these cases in our brief, but I see that as a expression of hope. And if you look at your cases in which this court has determined if it's a statement that is indefinite and infinite, because that statement is nothing more than a guarantee of employment for life, it is employment at will.
So we can assume that it's true And just as a matter of law, doesn't get the plaintiff where the plaintiff wants to be, which is a trial.
I think you're right. I think it is a matter of law. The cases we cited talked about employers saying things, you're going to have employment for life as long as you perform your duties, keep your nose clean, you'll keep your job, just do your job. We're not going to fire people. You have job security. All those kind of comments, when you parse them out or look at those kind of comments made, it doesn't form an implied contract of employment. What does form an implied contract of employment is when that single comment is connected with a course of dealing or a handbook that explains a progressive discipline policy, some arrangement in which there is a writing that talks about you can be terminated for just cause, and there is more than just a single statement of optimism. If you look at the cases that we've cited, that single statement of optimism, or parsing that representation to putative employees, is nothing more than just that. And what I think is interesting about the trial courts, or the Court of Appeals, of course, reversed, and we petitioned from that. But the Court of Appeals, I think, missed the boat by saying that this was, it went through the implied contract analysis, but then concluded that Mr. Peters' situation was one of more secure employment. I think this court has a long line of cases that talk about what constitutes at will, that includes those comments that I was talking about. And it has 3 or 4 cases cited by the Mr. Peters attorney that involve implied contracts where there is more than just a single kind of remark.
Counsel, can I stop you there and
Sure.
just ask a conceptual question that's bothering me? And that really is, can you help me understand what is an implied contract for employment? I know the factors that case law has talked about, but I guess I'm still struggling to figure out what exactly that is. Is there a meeting of the minds between the parties in an implied contract?
Well, it gives me the opportunity to say there wasn't a meeting of the minds here because nobody really understood what the terms were, and Mr. Peters has
Right, but
indicated.
that gets to, I mean, this is a strange legal creation, it seems to me.
Well, it is, and I look at it kind of like a fabric. It's a weaving of a whole lot of different things that Kastner delineates, and that weaving of the fabric creates that implied contract of employment that basically holds that you can't be terminated.
So is it a subspecies of an oral contract?
It can be, but I think it has to be woven with stuff that's not oral. If you look at your case law.
It seems to me that it's kind of it's kind of a misnomer. It's not the whole contract that's implied. I mean, this is kind of where the Court of Appeals started. They said there was a contract. He showed up. He got paid. There was a unwritten contract of employment. What's at stake, or what's at issue here, is an implied term of a duration term and a cause term. I mean, that's really what's implied here. It's not the contract itself, I think, conceptually.
Well, if that's the case, the implied term is indefinite.
That's what the fight is about.
And
whether
indefinite and infinite. And Mr. Peters indicated he couldn't be terminated for poor performance. He indicated that wouldn't answer the question if you show up and don't do your job, can you be terminated? So your case law...
Is that an issue here? Was there any allegation that he didn't do his job?
There was no allegation that he didn't do
In
his
this
job.
case, Mr. Peters is not alleged to have underperformed or non-performed, is he?
That's correct.
Okay.
Let me ask my question a different way. is this more akin to a promissory estoppel type claim where there is no requirement of a meeting of the minds, or is it actually a contract claim? That's what I'm trying to understand, if the legal mechanism here is designed to reveal whether or not there was a meeting of the minds on the terms.
There are two claims. One of his is contract claim, and the other is promissory estoppel. And with regard to the contract claim, there absolutely has to be a meeting of the minds, and there wasn't. And those statements that I've indicated, this court has said they don't constitute an implied contract. The promissory estoppel is a late after the fact change in deposition testimony in which the errata sheet had a reference to a severance agreement that was offered to folks. And our argument would be that this is a case of first impression because the representation actually came from Hitch, not from the purchaser, Deseret. So we have a couple of arguments about third party, number one, and number two, after the fact, late arrival on the allegation in an errata sheet.
Maybe I misunderstood what the arguments were about on promissory estoppel. I thought that your position was that your client had no reason to know of his forbearance in not taking the severance package.
We have argued that.
Okay, I thought that's what I understood.
Yeah, we argued that, but this late errata sheet change indicated that Hitch indicated at the department meetings in which Deseret was sitting there, passive, that they intended to do it by attrition and not by layoff. So the representation came from Hitch, not from Deseret. And I would tell you, Deseret completely denies that anything was ever said there. But if we get into that realm, we are in a question of fact. And I submit to you that because of the third-party nature of it, and because of the late arrival in the errata sheet, those two arguments, I think, are arguments that can be dispositive in this case as a matter of law.
Counsel, I can't get to it electronically. Did you guys get to a final pretrial order before the summary judgment order?
I don't believe so. Okay. I don't think we did. Can I reserve the rest of my time for rebuttal?
You may,
Thank you, Your Honor.
unless we have any further questions at this time. Counsel, just so I'm clear, your argument is that when the Court of Appeals says, according to Pruitt, who was the former manager, he said as people left, they're going to let their employees down through attrition as they left rather than to let them go. And your position is he is saying that Deseret representatives were making this representation, if I read this correctly, but your position is that does not matter because what was said is just fluff. It's not your word. But
expressions of optimism. I don't see that as any different than your cases that are real clear that says we're not going to fire people. I mean, what's the difference between a layoff and a firing? To Mr. Peters, it had the same effect. I don't see the expression of layoff being any different than your cases. And it's back to the fabric to create that implied contract of employment. It has to be knitted together with something else. And there wasn't a handbook, there wasn't negotiation, there wasn't a course of conduct. If you look at Kastner, all those facts, which counsel has ignored, but if you look at Kastner, all those factors that analyze at-will employment, whether it's an implied contract, are not present here. So I think it's unfortunate to Mr. Peters, but as a matter of law, this is an at-will employment.
And the Court of Appeals, in its conclusion on this issue, was talking about Deseret was impressed with the length of tenure of the Hitch employees, Deseret needed experienced employees to carry the business of the feedlot and care for the cattle. It warned two departing Hitch employees from trying to lure away any other Hitch employees. These are all apparently factors that they were mentioning to support their conclusion. What's your position on all that?
It's oral, and starting with Johnson, the cases have indicated that there has to be something more. There has to be more substance to it than just a representation. And my fear is, if this case is decided based on oral representation, Katie barred the door on lawsuits being filed anytime anybody is terminated. Because I evaluate employees, and when I sit and evaluate employees, I say positive things about them. And if you turn those expressions of optimism into an implied contract every time they're made, you're going to have a lot of wrongful termination lawsuits.
Well, how does your position square with our case law, whether it's Johnson or Hall, that says we look at 6 factors? For example, the party's conduct from the beginning of the employment relationship, the usages of the business, the objective of the parties giving rise to the relationship, the nature of the employment, and any other circumstances surrounding the employment relationship to explain the party's intent.
That analysis was examined by the Court of Appeals, and they determined this secured employment. I'm a big fan, because I happen to be involved in it, of the Kastner decision. And in Kastner, same factors, written or oral negotiations. Here, no. Conduct of employment over time. This started with a sale. There was no history of conduct over time. So that's a no. Business usage. He was a shop foreman. Shop foremen in feedlots all across Kansas are typically at will. The nature of the employment, same analysis. None of that squares with what your cases have said in the past. Constitutes an implied contract, in fact.
Let me ask one last question, at least on this go-round. According to the Court of Appeals, Mr. Peters, when he worked for Hitch, was an at-will employee.
Correct.
Is that correct?
Yes.
How does that factor, if at all, into your analysis?
Well, the trial court said he traded one at-will employment for another, and I would agree with that. He was an at-will employee who was hired by Hitch. There was an intention to hire him, and there was factors that indicated they intended to keep employees when they hired them, but there's no implied contract on the firing part. And all those factors weigh against Mr. Peters in terms of his belief that that statement of optimism somehow gave him secured employment. I think the Court of Appeals got it wrong. I think they've created an intermediary cause of action somewhere between at will and implied in fact contract. And I think that's a mistake.
I was going to ask Mr. Linder this, but it follows up on the Chief's question, and that is he was an at-will employee at Hitch, and as he transitioned to Deseret, what conditions of his employment changed? I couldn't see anything.
No,
I mean, wasn't he under the same understanding of his employment relationship with Hitch as he was with Deseret?
Yep, signed all the acknowledgments that said, I think there was a uniform or a drug and alcohol test, that he was an at-will employee. So it stayed the same.
I guess I misunderstood the facts. I thought that with Hitch, he knew he was at will because it was in writing, and he had acknowledged in writing that he was an at-will employee. Am I wrong?
No, you're right.
And did he do that same acknowledgement with Deseret?
No, there isn't an acknowledgement with Deseret. It just all the comments.
Well, I understand your argument, but that would be a distinction. He explicitly acknowledged being at will with Hitch, but when he took the new employment, his new employer did not take the same explicit acknowledgement.
No,
Is that true?
What the employer said was your job is going to be the same.
Okay.
So my position would be at will to at will.
Okay.
Any more questions? Thank you, counsel.
Please the court, John Lindner for appellant Douglas Peters. This is very much a jury question, the intent of the parties to an employment contract. There are case after case after case, and the intention of the parties, even the Johnson case, which the trial court relied upon, says that the duration of employment depends on the intention of the parties as determined by the circumstances in each particular case, and the intent of the parties to an employment agreement is to be determined by the circumstances in each particular case, and this determination is a jury question.
Counsel, does that mean that you would agree that this, what we call implied contract for employment is really just a plain vanilla contract claim that maybe is harder to prove up? And that all these factors that we talk about, the Hall factors or whatever, they're all really just ways to prove up the old Contract 101 elements of a contract.
It is. Okay. And this allegation that these are expressions of hope, I wouldn't want to try to explain that to Mr. Peters or anyone in his position. I mean, he is clearly going to be in a position of listening to these representations, to these promises, and he is going to rely upon them.
So how does that change his understanding of his relationship between Hitch, which was an at-will, and
Sure.
what he has here? How do these kind of comments change his basic understanding of his employment relationship?
Well, because Deseret is seeking to keep him around for all of the reasons that are very well documented. They had 45,000 cattle in this feedlot. It was a 24/7 operation. They had to make this switch. They had to keep these people. They threatened the Hitch upper management not to try to take these people because they needed to keep them. They made the representations to him. If we reduce the workforce, it's going to be through attrition and voluntary retirements. No one is going to be laid off. If you do your job satisfactorily, you'll continue to have your job. All these representations were made, which is completely different than the arrangement that he had with Hitch. I mean, it's acknowledged by Mr. Peters that he was an employee at will with Hitch. But these representations were made to try to make sure that he came to work for the new company. And he did. He relied upon these promises.
Well, counsel, you've said that twice. You used the word promise and reliance. And those, my understanding at least, those aren't really terms that we use in the context of contracts. We would more talk about an offer and an acceptance and consideration. And so that's what I'm trying to get at. If this is really a contract claim, don't you have to show those classic contract elements? Not a promise, not just, I promise, if I say I'll give you $100 when this oral argument's over, we don't have a contract. I've made a promise, but we don't have a contract, right?
Point taken. It's an offer.
So was there an offer and an acceptance?
Absolutely. An offer of employment, and it was accepted on the terms offered. It was much more than an expression of hope. It was very definite, and and I'm going to mispronounce this. I don't know why I have such a tough time with this. Allegri or Allegri, I don't know which it is. That case it just shouts out the Peters case. The offer of employment was the same. The expression was that the employment agreement was that Mr. Allegri would continue to work as long as his job performance was satisfactory. The district court, for the exact same reason, as the Peters case, no definite term of employment granted or a summary judgment. The Supreme Court, the Court of Appeals said no, summary judgment should not have been granted, and it is a jury question as to whether or not there was mutual intent. It's I have argued all along that you'll have your job as long as your job performance is satisfactory, as long as you do your job satisfactorily. It's just another way of saying that you will not be terminated but for cause. But I don't have to make that allegation thanks to the Allegri case, because the offer and the acceptance was the exact same language. As long as you do your job satisfactorily, your job will continue. You will have your job. I hate to repeat this jury question thing, but that's the bottom line. This is a jury question. Summary judgment was not proper, and the Court of Appeals got it right, and it should be remanded, and it should, Mr. Peters should have his day in court.
Counsel, I'd like to go back to one example. There has been some confusion, I think, as to the timing of when representations were made and who made them. For example, Mr. Guerrero, the Court of Appeals talked about him and said that Deseret told employees that they did not have to worry about their jobs, but that this occurred after Deseret took over the feedlot. Would you agree that what they said after the feedlot would not be an enticement for him to enter employment with Deseret?
Yes. Mr. Guerrero is the only one that says that, and his deposition was not a pretty thing. He got up and walked out, got mad. But yes, he did say that. He said that they, right off the bat, they fired 5 people and then said, the rest of you, as long as you do your job satisfactorily, then you don't have to worry about losing your job. He's the only one of all these people that said that. The others...
Excuse me, whose obligation or duty is it to establish the date in which something like that would have been said? Is it your obligation as the plaintiff? In other words, you're opposing a motion for summary judgment. You must come forth evidence to establish a dispute as to a material fact. Or is it the defendant's obligation to establish the date? And if he cannot, as the Court of Appeals seem to suggest, then that falls in your favor and it's improper for summary judgment.
Well, all inferences are to be determined in favor of the party opposing the motion for summary judgment. So I don't know if that answers the question. Now, when we got to trial, of course, I would have to deal with the Guerrero issue, but I've got, as far as the timing of the offer, as I said, all of the other evidence supporting the offer and that the offer was made was pre-employment. It was at the time, it was during the time when Hitch was selling the feed yard to Deseret, and Deseret was trying to keep the Hitch employees.
Let's talk about people who left employment. For example, I believe the Court of Appeals has said that 8 out of the ditch employees, after they had started working for Deseret, quit. Is that right?
I'm not sure of the number, but I know there was some evidence that there were some people that left, yes.
And were they allowed to leave freely, or were they held to a, quote, implied contract, end quote, and prohibited from leaving?
I don't know that. I don't have any evidence that they were held and not allowed to leave. I don't have any evidence of that, no.
Well, our case laws seem to suggest that the employer and the employee are free to end the employment relationship if it is a true at-will situation. So my question is, if they were allowed to freely leave, how does that, if at all, fit into your case?
I think that each individual case must be looked at separately, and I say that because this, like every other lawsuit that I've been involved in, the facts are never perfect. They're never clean. The memory of some of the people is that this was a wholesale offer to all of the employees. The most credible witness, Mr. Pruitt, said that these offers were made to the department heads. That's his memory, and he was in on those meetings, and he was in on the meeting with Mr. Peters. So it could be, it could be that the same offer was not made to every employee. I, of course, am concerned only with Mr. Peters, and I believe there is good evidence that the offer of employment under these terms and circumstances was made to Mr. Peters.
Okay, well, let's stick with Mr. Guerrero. As was mentioned earlier, according to his deposition testimony, 5 people were fired after they began work for Deseret. Is that right?
That's what he said, yes. Mm-hmm.
Okay. Do we know if those were for cause?
No, I have no idea. He made that comment in his deposition, and I would surmise that they were not for cause because of the way he put it. He said they were just fired right off the bat, and then everyone else was assured that as long as they did their job, they would not be fired.
And assuming that to be true, that they were fired without cause, does that have any bearing on your argument that your client can only be fired for cause?
No, because as I said, I think it is an individual thing. We don't know for sure what offers were made to what individuals or what department heads or whatever. We only know of the offer specifically that was made to Mr. Peters and accepted by Mr. Peters. I can't speak for the entire workforce. So, and as I said, the facts aren't perfect, but they certainly are such that they must be determined by a jury, and the intent of both the employer and the employee must be determined by a jury.
And just so I'm clear, are you saying that the representations that you build your case of implied contract of employment on had to be made directly to Mr. Peters?
Yes, they were made directly to Mr. Peters. Now, who else was present, there is conflicting testimony on, and how many other people the offer was made to at any particular time. There's conflicting evidence on that, but it was definitely made to Mr. Peters, and we have Mr. Pruitt, who I consider to be the most credible and the strongest witness on that point to verify that.
All right. Thank you, counsel.
Thank you.
Do we have any more questions? Thank you.
I want to take issue. Thank you, Your Honor. I want to take issue with interpretation of Allegra, and that is in Allegra, he worked for the same employer that he had the case against for nearly 30 years. So there was a history of employment in Allegra, and there was an employee handbook that explained that you could be terminated for just cause and had a progressive discipline policy. My point with Allegra is I'm sorry, my
Go
point
ahead.
with
Go
Allegra is that Peters is nothing but oral representations. That's what is made here. And it doesn't have the same texture that your implied in fact contract cases do, like Allegra, where there is written evidence in a handbook or a stipulation, which is the Morris case, for termination for just cause. This falls short of that, and
It
is
falls short, but there's other time factors that maybe plays into this. You're looking at these optimistic statements about working conditions, as you characterize them, that were made in the late fall of 2010, and that would allow then for Desiree to kind of have a smooth transition with these employees. And in less than 6 months, the statements don't hold true. And Peters is terminated, he's offered a severance. Does that factor into anything here? Is there any kind of, here these promises are made and then within 6 months, they're no good anymore. These were just optimistic statements. Sorry about that.
Mr. Peters was not the first person that was let go. And the
point is the timing of this. If you're looking at it, it allows for Desiree to have somewhat of a smooth transition with continuity of employees based upon these representations, partly to keep these employees, and then within 6 months they're out.
Yeah, but I separate the decision and the representations made to hire from firing. And in terms of Mr. Peters, he was let go some 7, 8, 9 months afterwards. In the meantime, 20 people left. And in terms of this being, and that's uncontroverted, in terms of this being a representation of secured employment for an indefinite period of time, if that constitutes a contract,
Certainly not indefinite, but you would think perhaps more than a couple of months.
I don't think it's a contract at all. It is, and the court decisions have talked about employment at will contract or an at will contract. I think if it's at will, there's no contract. And here, I say there's no contract.
Excuse me, counsel.
I don't understand the significance of the people who left in between the time that he was said, these things were said, and the time to him and the time that he was let go. What's the significance of that?
Because it's all at will. And their leaving is...
But they left for different reasons, right? They weren't all let go, were they? Some of them left on their own?
Some of them left on their own,
Okay.
some of them were terminated, but it's all at will.
Counsel, if a plaintiff sues a defendant for breach of contract, plaintiff says, we had a contract, defendant says, we didn't have a contract. Don't you have a jury question?
No. If there are...
Isn't that a disputed material fact?
No. If there are undisputed facts that form the basis and your case law that indicates that the statements made do not form the basis of a contract, that's a question of law. And oftentimes, when we follow the law, as you know, there's winners and losers. And in this situation, Mr. Peters, his situation is unfortunate, but if you follow the law on what you've said about oral contracts and these kind of representations, then the law dictates what the result is.
So we look to the more granular evidence of what the statements were rather than the parties' representations as to what was in their minds.
I don't think you have to get to granular. I think you look, and it is undisputed that all these comments were oral. And if you look at your cases that found implied in fact contract, Morris, Allegra, Brown, they all involve a handbook or a writing or a history that indicates that there is more to that implied in fact contract than just an oral representation. Thank you, Your Honor.
Do we have any more questions? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.